This segment was all about property titles and how they're transferred. We identified what the title to a property is, and we discussed title searches and title insurance. Titles are the legal basis for ownership of almost any kind of property. The title is what normally lays out a property owner's bundle of rights. So when a piece of real estate is bought or sold, the title to that property is the thing that actually changes hands. But a title can be a complicated thing that's affected by a number of conditions. When someone's considering selling a property, they'll often have a title search performed. This can provide a complete history of the title, including information as to who actually owns the property, allowances and restrictions on the use of the property, and defects and problems with the title that carry financial risk. Common examples of evidence of a person's ownership called title evidence include certificates of title, Torrens certificates, and property abstracts. Title insurance policies are drafted to protect parties with financial interests in a property from losses associated with title defects. While usually purchased by a title holder, the insurance really protects lenders and investors in the property. Because title insurance is a backed guarantee that a title is clear of defects, the insurance can be used as evidence of a party's ownership. From there, we moved into a review of non-possessory interests and title clouds. A non-possessory interest is a right or set of rights that a party has for a property they don't own. This can include interests like easements, profits, covenants, and equitable servitudes. Easements are interests in a property that allow for access or use by a party that doesn't own the property. They can include private interests that allow someone to drive through a portion of another person's property in order to access a public street. Easements are also used by public entities and utility companies to place and maintain piping and power lines. Easements can be explicitly stated, inferred by the use of a property and the way it was subdivided, required by an emergency situation, or granted to someone using a property they don't own if they meet certain specific conditions. Profits are like easements, but also allow the removal of some kind of material resource. Covenants are contractual agreements that restrict or control the use of a property or properties by the affected property's owners. The breach of a covenant is considered a breach of contract and can be remedied through monetary damages. Equitable servitudes are similar to covenants, but they are not contractual agreements. A breach of this kind of non-possessory interest is usually remedied by an injunction stopping the prohibited action. Clouds on titles are problems that inhibit the ability of a party to transfer them. Clouds on a title can include defects and errors in a title, liens from unpaid mortgages, and property disputes resulting from encroachments. Liens are legal claims made on another person's property for the purpose of securing or repaying a debt to the holder of the lien. These are imposed by both lenders and government agencies. The holder of a lien usually retains the right to seize and sell the property if the debt goes unpaid. Encroachments are situations where a property owner has built or extended a structure partially or wholly onto a neighboring property. Unresolved property borders and encroachments can be clouds on a title, since they make it difficult to discern the actual dimensions of a property. Then, we talked about the process of transferring a title. Transfers of title occur whenever a property is bought, willed, or given away. Titles are most often transferred through the sale of a property. Probate, adverse possession, and eminent domain are particular methods by which a title is transferred as well. Deeds are legal documents that most often either passes or confirms the passage of an interest, right, or property to another person. They are written instruments that usually require statements of intent, signatures from the party passing the interest, the grantor, and witnesses. Deeds must also be delivered and accepted by the party receiving the interest, the grantee. They are also matters of public record, meaning that copies of them are placed into county records. The three most important deeds that a real estate professional will be dealing with are grant deeds, warranty deeds, and quitclaim deeds. We also addressed a special means of transferring ownership known as a 1031 exchange. In this process, which is governed under Section 1031 of the Internal Revenue Code, an owner sells a property and then buys one or more properties within a specified limit. If this process is carried out under the rules, taxation of the exchange is deferred. And finally, we discussed the Michigan-specific rules governing transfers of title and state transfer taxes. Now, you should have a clear picture of what a property title is and what's involved in transferring that kind of title. Going forward, we'll shift focus to the financial side of real estate transactions, starting with a look at mortgages.